Mitigating Circumstances, Article 13 of the RPC, Part 4. People vs. Magpantay. Facts. In the night of May 8, 1947, Felix and Pedro took turns to guard, so that when one was asleep the other was awake. At about 9 o'clock, when Pedro was asleep, the silhouette of a man passed in front of their house without any light. The night was dark and it was drizzling. The coconut trees and the bushes on the sides of the road increased the darkness. When Felix saw the silhouette, he asked it who it was, but it walked hurriedly, which made Felix suspicious, as it might be a scouting guard of the Dilim gang. Felix fired into the air, yet the figure continued its way. When Pedro heard the shot, he suddenly grabbed the rifle at his side and fired at the figure on the road, causing the death of the man. This man was afterward found to be Pedro Pinion, who was returning home unarmed after fishing in a river. The accused voluntarily surrendered to the barrio lieutenant and then to the chief of police. Held. The accused acted under the influence of the fear of being attacked. Having already in his mind the idea that they might be raided at any moment by the Dilim gang and suddenly awakened by the shot fired by Felix, he grabbed his gun and fired before he could be fired upon. The fear, however, was not entirely uncontrollable, for had he not been so hasty and had he stopped a few seconds to think, he would have ascertained that there was no imminent danger. He is entitled to the mitigating circumstance of grave fear, not entirely uncontrollable, under paragraph 1 of Article 13 in connection with paragraph 6 of Article 12 of the Revised Penal Code. That said, two provisions may be taken together to constitute a mitigating circumstance has been declared by the Supreme Court of Spain in its decision of February 24, 1897, and by Groizard. Código Penal. Consequently, there are two marked mitigating circumstances in favor of the accused. Article 64, in paragraph 5, of the Revised Penal Code provides that when there are two or more mitigating circumstances and no aggravating circumstances are present, the court shall impose the penalty next lower to that prescribed by law, in the period that it may deem applicable, according to the number and nature of such circumstances. The penalty for homicide is reclusion temporal. The next lower penalty is prison mayor, which may be imposed in the period that the court may deem applicable according to the number and nature of such circumstance. In view of the foregoing, this court finds the accused Pedro Magpantay guilty of homicide, with two very marked mitigating circumstances, and modifies the judgment appealed from by imposing upon him the penalty of from 6 months and 1 day of prison correctional to 6 years and 1 day of prison mayor. With due respect, it is believed that Art. 69, in connection with paragraph 6 of Article 12, not Article 13, paragraph 1, in relation to paragraph 6 of Article 12, should be applied. When it considered grave fear, not entirely uncontrollable, as ordinary mitigating circumstance under Article 13, paragraph 1, together with voluntary surrender, and applied Article 64. The Court of Appeals should have fixed the maximum term of the indeterminate penalty, prison mayor, in its medium period. The two mitigating circumstances having been considered already for the purpose of lowering the penalty for homicide by 1 degree, pursuant to paragraph 5 of Article 64. There is no mitigating circumstance that will justify the imposition of prison mayor in its minimum period. Had Article 69 in connection with paragraph 6 of Article 12 been applied, the penalty imposed would have a correct basis. Under Article 69, the penalty 1 or 2 degrees lower than that provided for the offense may be imposed. The mitigating circumstance of voluntary surrender need not be considered in lowering the penalty by 1 degree. Therefore, the voluntary surrender of the accused, which is a generic mitigating circumstance, may be considered for the purpose of fixing prison mayor in its minimum period. Art. 64, Paragraph 2. Paragraph 2. That the offender is under 18 years of age or over 70 years. In the case of the minor, he shall be proceeded against in accordance with the provisions of Article 80, now Article 192, PD number 603. Paragraph 2, Article 13 RPC impliedly repealed by Republic Act No. 9344. Paragraph 2, Article 13 of the Revised Penal Code providing that offender under 18 years of age is entitled to a mitigating circumstance of minority is deemed repealed by the provision of Republic Act No. 9344 declaring a child above 15 years but below 18 years, 18, or age shall be exempt from criminal liability unless he/she has acted with discernment. Section 6, Republic Act No. 9344. In other words, whereas before, an offender 15, or over but under 18 years of age is entitled only to the benefits provided under Article 68 of the Revised Penal Code. Under Republic Act No. 9344 or the Juvenile Justice and Welfare Act of 2006, such offender may be exempt from criminal liability should he/she acted without discernment. On the other hand, if such offender acted with discernment, such child in conflict with the law shall undergo diversion programs provided under Chapter 2 of Republic Act No. 9344. Meaning of diversion and diversion program under Republic Act No. 9344. Diversion refers to an alternative, child-appropriate process of determining the responsibility and treatment of a child in conflict with the law on the basis of his/her social, cultural, economic, psychological, or educational background without resulting to formal court proceedings. Section 4, Republic Act No. 9344. Diversion program refers to the program that the child in conflict with the law is required to undergo after he/she is found responsible for an offense without resorting to formal court proceedings. Section 4, Republic Act No. 9344, System of Diversion. Children in conflict with the law shall undergo diversion programs without undergoing court proceedings subject to the following conditions. A. Where the imposable penalty for the crime committed is not more than 6 years imprisonment. The Law Enforcement Office or Pananbarangay with the assistance of the local social welfare and development officer or other members of the local councils for the protection of children, LCPC. established in all levels of local government pursuant to Republic Act No. 9344, shall conduct mediation,